for work, but
just a quick reminder before Chirstina gets going, please keep your videos and your microphones off during the presentation. And also, if you have questions, we are going to do the questions at the very end. So just type them as they come to you in the chat box, and I will relay them to Chirstina at the very end of her presentation. Thank you guys again all for being here today. Chirstina.
Thank you. Thank you. I appreciate all of you taking your time to sit through this presentation. I hope it's going to be helpful. My name is Chirstina Wenko, and I am I'm the partner at Makoff Kellogg Law Firm in Dickinson, North Dakota. Part of my primary practice is representing landlords through eviction processes, reviewing lease agreements for private clients, and so forth. So I got several years of experience under my belt handling these types of cases. So I'm hoping that this can be an informational session for all of you, give you an opportunity for us to answer any questions that you have as we move forward. So as Kylie indicated, I will take questions at the very end and we'll get started. So hopefully we can, everybody can see my screen here as we get up and running. So give me a moment here. Okay, again, Chirstina Wenko, Makoff Kellogg Law Firm. So initially what we want to know is what is an eviction? And very simply stated, it's the legal process to recover the possession of real estate. In North Dakota, there are 8 statutory allowances for when an eviction is appropriate. We'll just go through them very briefly here. And of course, if you have any questions, we can certainly answer them at the very end. Number 1, a party by force, intimidation, fraud, or stealth has entered upon the prior actual possession of real property. Not one that usually happens all that often. Number 2, a party after peaceably entering real property turns out by force, threats, or menacing conduct to the party in possession. Also one that doesn't happen very often. Number 3, a party by force or by menaces and threats of violence unlawfully holds or keeps possession of any real property. Again, doesn't happen very often. Number 4, a lessee in person or by subtenant holds over after the termination of the lease or expiration of the lessee's term or fails to pay rent for 3 days after the rent is due. This is one of the more primary examples of when we're going to see the eviction process come into play. Number 5, a person continues in possession after sale of real property under mortgage execution order. Simply, if there's a mortgage and there's a default and there's a foreclosure, that person remains in the premises. Number 6, a person continually wrongfully in possession after a judgment in partition or after a sale under a court-ordered decree. Number 7, a lessee or person on the premises with the lessee's consent acts in a manner that is unreasonably disturbs the tenant's peaceful enjoyment of the premises. That's one of the other big ones. We allow parties, things of that nature. And then finally, number 8 is the catch-all, which is where the lessee violates a material term of the written lease agreement between the lessor and the lessee. So under the statute, as I said, there are 8 reasons or 8 statutory allowances for an eviction. So let's delve into what the eviction process actually involves. So as I had indicated, one of the big ones that we normally see is failure to pay rent. This is the most common reason for evictions. And again, it's basically simply stated, a lessee in a person or by subtenant holds over after the termination of the lease or expiration of the leasee's terms, or fails to pay rent for 3 days after the rent is due. Very important that you check your lease agreements. It probably not so much for the larger landlords or the commercial type of properties, or the landlords that have a lot of the other units, but to make sure that your lease agreement provides very specific remedies on what happens when rent is not paid timely. Does your lease provide for late fees? Things of that nature. It's very important to make sure that they're in the lease agreement. Also, too, you want to make sure that your lease agreement is in compliance with North Dakota law. Sometimes The lease agreement will be drafted in such a way where you have to give the tenant additional notice that may not be required under the statute. So under the North Dakota statute, you must give 3 days notice prior to instituting any sort of eviction process. Now, if your lease is drafted where it says that you have to give them 30 days notice, or anything of that nature, so if it's different, you just want to double check and make sure, because that can cause additional timing requirements and additional notice that you'd have to give before you commenced eviction. The next big one is disturbing the peace. We see this a lot. You know, if you've got sometimes when we've got college tenants of younger age, not so much. You know, see this in some of the party houses. So this is essentially where a tenant is unreasonably disturbing the peace and enjoyment of the property. You want to make sure that your lease includes this provision as a material term or a material breach of the lease. Some of these examples could include loud parties, loud music, fighting, you know, if you've had some of those, erratic behavior, if you've got someone banging on the walls at all hours of the night, those can cause issues as well, and those could rise to disturbing the peace type of situations. Secondly, we've got, third most common is material breach of the lease. This is essentially, very simply stated, when the tenant violates material term of the written lease agreement. You want to make sure that your lease agreements include this language, and it can be something very simple as violations of the smoking policy, the pets, the cleanliness, upkeep of the property, and illegal activity. So if your lease agreement or if your unit does not provide for smoking, then make sure that your lease agreement provides that. Same with pets. If you've got to make sure that the tenant is reasonably put on notice that they are to make sure that the property is kept in upkeep, then there should be a cleanliness provision as well. And then also too, a catch-all, when it comes to illegal activity on the property, that a tenant would be responsible for complying with all state, local, and federal laws. And this would include obviously making sure that there's no drug paraphernalia or other criminal activity happening on the property. Any one of those would and could result in a material breach of the lease agreement. So what is the process? First and foremost, the first thing that we're going to look at is step one, which is what I refer to as the notice to quit to the tenant. This is the process, or the step in the eviction process where we put them on notice of what is happening. And the first step in that is to determine what is the violation. What are we working with here? Is this a failure to pay rent situation? Is this a disturbing the peace, or do we have some situation where maybe they're doing drugs in the apartment, or they're smoking? Whatever the situation is, determine what that violation is. Second step would be to send a notice to quit. That's the technical term. When we send them, we call them we call them a notice to intent to evict and a termination of lease. So the way that we draft our documents is a twofold. It's one, to tell them that you've got 3 days before we're going to formally start the eviction process, but it also informs them that we no longer intend to continue this lease. So there's a notice of termination of lease. And this is 3 essential things that we feel are important to make sure that the tenant is aware of in the initial process with the eviction. We recommend, and it's that notice is personally served on the tenant. So you can attempt service personally. We recommend for these types of proceedings that you always try to have a third party serve the notice, and then they give you a return of an affidavit of service. That can be done by a sheriff's office, or it can be done by a process server. We really recommend this because then it takes out the whole situation where a tenant could come to court and say, well, I never got that notice. Well, yes, you did, because we have a sheriff's notice that says that you were served by a sheriff, or we have a signed sworn affidavit saying that you were served by a process server. Some landlords will do what they call a certificate of service, where it's essentially the landlord serving the notice, and then they sign it under penalty of perjury with a notary that says, I served this notice on so-and-so and such a date. We have allowed that. Some of the judges have questioned that in our district, but some of them allow it. But we typically recommend, for all intents and purposes, have someone else do it. Have, pay $50 to have someone else do it. And that way there's no question that this person was served the documents. And if there's any question or concern about it, there's an affidavit sworn by a third party that says, on such and such a date, I served this person. The notice to quit is basically instructions to the tenant to vacate the property. They must be given 3 days notice before a landlord can proceed with an eviction, and that's statutorily required. If the tenant does not vacate, then we proceed with a summons and complaint. So that leads us to step 2, and that's the actual summons and complaint process. It is the official court action for removal of a tenant. The purpose of the summons and complaint is twofold. The summons is the legal document that informs the tenant of the time and place of the hearing. This is very interesting because North Dakota statute requires that that notice cannot be served on a tenant not fewer than 3 days, but not more than 15 days prior to the date that the summons is served. So you have to make sure that when you are serving that summons and complaint, that it fits within that 3 to 15 day window, because if it doesn't, then you could be you could get thrown on court. You might have to start the eviction process over. So it's very important that when you're going through that process, whether you're working through a lawyer or you're doing it yourself, that you're abiding by those notice timeframe requirements. The complaint is the second document that gets served with a summons, and the complaint outlines the reasons for eviction. Whether that's failure to pay rent, it would outline how much rent is due, when it was supposed to be paid, if there's breaches of the other lease, if it's disturbing the peace, anything of that nature, any violations are going to be included in that complaint. The summons and complaint must be personally served on the tenant. There's no getting around that. We definitely recommend that if you are going to serve a summons and complaint, that you have it served by an independent third party. That can be a sheriff's office or a private process server is what we typically recommend. The interesting thing about the summons and complaint is the law in North Dakota allows that service, or provides that service has to be attempted at least once between the hours of 6 p.m. and 10 p.m. If you attempt service during those time frames and you attempt it once and you're not able to locate the tenant, state law provides that those documents, the summons and complaint, can be posted on a conspicuous place on the property. The reason why we are allowed to do this by statute is because, let's face it, some tenants duck service. They know that they're going to be receiving these papers and they think, man, if I'm not home, I don't got to worry about it, and it's only going to prolong me being able to stay in the unit. Well, that's not what North Dakota law provides for. It allows them to attempt it once. If they're not able to find that person, they post it on the property and then service is complete. Same process. The sheriff's office or the process server would provide the landlord or the attorney working for the landlord an affidavit of service that says, I attempted service on such and such a date, I was able to complete service, or I had to post it, and that would be right in the affidavit of service. All service documents for the notice, summons, and complaint have to be filed with the court prior to the eviction hearing. That is to inform the judge that the tenant has been made aware of these proceedings, that the statute has been complied with, and all of the notices have been properly given. So when we go to eviction hearings, the judge always looks to see, do I have a service document for the notice? Do I have a service document for the summons and complaint? Because the whole process of the court proceeding is to make sure that the tenant is aware of the proceedings, that they have been instructed and notified the complaints against them so that they have an opportunity to defend those allegations. So then we get to the hearing process. So if they do not vacate after receiving the summons and complaint, then we actually proceed to the hearing part of it. which is where we go in front of a court and then we have a judge preside over the eviction case. If the tenant does not show up at that hearing, you essentially obtain a default judgment, which is basically the court saying to the landlord, I'm giving you what you're asking for. I'm giving you possession of the premises. If you're asking for past due rents, I'm also going to award those. So it's based on what you've pled in your complaint, and what you're asking for is typically generally what the court would award you. If the tenant does show up, then the landlord must present evidence supporting the eviction. So if it's a situation where rent isn't being paid, then typically you're going to need testimony from the landlord or the property manager regarding terms of the lease, the ledger, past due balances, things of that nature. If there's a situation where there's property isn't being kept up, or you've got pets in the unit, there may also be photographs that are presented at the hearing to support the reason why this tenant is in violation of the lease agreement. The tenant also has the opportunity to testify at the hearing. The interesting thing about the North Dakota statute is if you actually read the eviction statute, it's very, very short. And so in a lot of respects, it's landlord friendly because the tenant is actually statutorily prohibited from raising any counterclaims except to set off a demand made for damages and for rents or profits. So if a tenant comes in and says, Your Honor, this is an unlawful eviction because I had an agreement with this gentleman that rent was going to be, I was going to do this other thing where I was going to have this other agreement totally unrelated to the property or the lease or the eviction, the judge is going to say, I'm sorry, but that's not why we're here. All the judge is concerned about is, what does that lease say? Is there a violation, and has it been proven? And if so, the court is really kind of stuck in what they can essentially award anyone. And so the court will issue a ruling upon introduction of all of the evidence coming from the landlord, also coming from the tenant. And then you're going to get the decision. And if the court finds for the landlord, the court shall enter judgment for immediate restitution of the property, which means I'm going to give you the property back right now. We're going to issue a judgment that says, landlord, you can go back into this property and you can start getting the property back. If the tenant demonstrates that immediate restitution would be a substantial hardship, the court may grant the tenant up to 5 days to vacate the property. This happens a lot. I see this happen, in a situation where it might be the winter time, or if there are young children involved and, they show up and say, well, I've got children, I need to make arrangements for this. The only exception is if the allegations against the tenant are for disturbing the peace, then immediate possession is granted. The thought process, if you're going to continue to disturb others, then it's not only an imposition of the landlord, but it's also an imposition and causing issues for other people within the premises. The tenant and the landlord can agree on additional time if they're at the hearing and say, the landlord says, I will allow you to have 10 days instead of 5. That can happen. It's just that the parties have to agree on it. It's not something that the judge can award. The judge is statutorily allowed 5 days and 5 days only. That's the most that the judge can give. If you're a situation where you're renting a larger farmstead, or maybe there's equipment or something like that, it's not unreasonable for a judge to say, given the fact that we're talking about substantial equipment or something that has to be moved, that they would allow that additional time. Ultimately, when the hearing's completed, the judge will issue a judgment for eviction, outlining the terms and conditions of the court's decision. Oftentimes that comes with an order for past due rents to be paid. You also want to make sure that your lease agreement provides for attorney's fees, because in North Dakota, you cannot get attorney's fees unless it is statutorily allowed or it is by a contract. So in this situation, the only way you would get them is if your lease agreement provides that you are entitled to receive attorney's fees. So if you in fact have that lease provision in your lease agreement and you put it in your complaint, then it would come into your judgment. So then your judgment would include the $500 or $700 or however much the eviction cost you with an attorney. That can be added onto the monetary judgment that would be awarded by the court. Now, if the court grants the eviction judgment and it says immediate restitution of the premises, then that's what the judgment says. If the judgment says you get 5 days, then what the landlord should do is follow back up with go back to the premises within 5 days and see if that person or the tenant has vacated. If for some reason the tenant has not vacated, the next step is to secure a writ of eviction from the local clerk of court's office. This is issued by the county clerk of court, and it has to be executed by the sheriff's department. So having said that, some special consideration is do not, I cannot stress this enough, do not employ any self-help methods or remedies as a landlord. Unless you have a judgment that gives you restitution of the premises through the eviction process, do not change the locks, do not remove personal items, because you can get in some serious trouble with some treble damages if you are engaging in any of these types of remedies. So I always advise our clients that do not take any action with that property until I give you the go-ahead with a court judgment that says you have immediate restitution of these premises, or if they're in the unit still, then I'm going to send a sheriff over there with a writ, and they are forcefully going to remove that person from the property. But you, landlord, are not going to do that. The sheriff's office is going to do that. Another consideration is make sure that you document all of your communication with your tenant, whether that's text, emails, notices, or whatever the case is, because you always want to make sure that you have that information in a documentable form. So if you ever get questioned on it, or it comes up, or the tenant says, landlord never told me that, you have an ability to refute those claims. And it's just important, and quite frankly, it's good business practice to do that. Some other special considerations, I've gotten some questions over the years regarding service animals. Just a few kind of points I want to make on this. Service animals are not pets. According to the Housing Administration, your service animal is not required to be trained or certified. You have to evaluate a reasonable, you have to request a reasonable accommodation. And there's two typical prongs to that test, and that is, does a person have a disability, and is there a disability related need for the service animal? Another thing that the landlord can factor into whether this is appropriate is there a factor, is there a direct harm or threat to others? For example, if a tenant says, I need a service animal, and they want to come in with a mountain lion, probably not going to happen. Or if it's a boa constrictor or a rattlesnake or something, I mean, you'd be surprised, what comes up. But those are types of considerations you say, well, I don't think that that's such a good idea. And so you also have the ability to ask for documentation if the disability is not readily apparent. So I always encourage my clients and landlords to be deferential about that. Obviously, we don't want to pry too much into particular tenant's situation, but you do have the authority to ask for some of that to solidify and understand why the request is being made. Also, another big one that's come up recently is obviously the considerations with COVID-19. We've had some unique situations in the state of North Dakota as well as nationally. Previously, the North Dakota Supreme Court had issued a halt on evictions. That has since been lifted. The reason why the Supreme Court did that was because of that 3 to 15 day service window. We weren't able to get sheriff's offices or other individuals out to serve things timely, and so it wasn't making sense to continue with that because we couldn't meet the service requirements. But since then, the North Dakota Supreme Court has lifted that stay for evictions. However, the CDC has and did issue an emergency public health order that halted most evictions. That order was and is good from September 1 of 2020 through December 31st of 2020. So at the end of this month, that is set to expire unless they extend it with potentially additional relief action. I did see that that would be a potential possibility. One of the big one of the big items of the potential relief bill that's on the table is a moratorium on evictions. To what extent, I do not know, but that is something that could come down at the federal level eventually, maybe within the next month or so, who knows. But essentially what that CDC order required was the tenant to execute a declaration under the penalty of perjury. So I view that as a requirement that the tenant must take an affirmative action to halt the eviction. It's not just to say, oh, I don't want the eviction. They have to come to the landlord. They have to sign a document that says a few things. One, that they don't expect to earn more than $99,000 in 2020, or they received a CARE stimulus check, that they have used their best efforts to obtain government assistance for rental housing. They're unable to pay rent due to substantial loss of income or medical expenses. They've made an effort to make at least partial rent payments. There are no other available housing options, and they acknowledge that they may need to pay back rent and fees once the moratorium expires. So the way that it's structured, it allows the landlord to still collect on past due rents. Those are not simply forgiven because the eviction process is halted. These CDC requirements only apply to those unable to make full rent payments. And again, it does not prevent evictions resulting from other issues related to the failure to pay rent. So if you're being evicted because you're a nuisance and you're a disturbance, then I'm sorry, but the CDC isn't going to cover that. That's not what's covered on the order. And then also, in the final point, landlords are not required to forgive payments, fees, penalties, or interest. So you may be able to stay in the unit for a short period of time without paying rent, but ultimately it's going to catch up with you at some point. And once the moratorium is lifted and the landlord is required to, or is allowed to proceed, then at that juncture, you may be facing a whole lot of past due rents for the time that you have, or the tenant has been staying in that unit. We have been proceeding with evictions during this time only in the event that a tenant makes the affirmative declaration under the CDC, have we stopped and not proceeded. So that's, again, a requirement of the tenant to do that. Now, as a landlord, I think that I always encourage, try to be deferential to your tenants if you can. Provide them the opportunity, say, listen, there's this CARES Act out here, there's this order. If you want to take advantage of it, certainly sign it, send it back to us. At least you say that you've given the opportunity, that they know about it. And if they choose not to sign it and take advantage of it, well, that's on them. But at least you, as the landlord, have told them about it. You've given them the opportunity, and the ball's in their court at that time. Whether they act on it, that's their choice and that's their decision. Okay, so that was the short and very quick version of landlord evictions in the state of North Dakota. I will be happy to take any questions that anybody has, and we can go from there.
We do have a few questions.
Sure.
We will start with.
I accidentally muted you. I'm going to jump in here. I muted her by accident. The first question is, to be clear, if there is not anything contrary to the lease, you can evict for non-payment 3 days after rent is due and give them only a 3-day notice.
Correct, unless there's some other provision in the rental agreement that says you are required to give them additional notice or a time to cure their default, then yes, you can proceed upon a 3-day notice saying, I'm going to proceed with eviction.
Okay, looks like Kylie's back on, so I'll let her take over there.
I don't know what happened there. Next one, there seems to be some confusion on the 3-day notice. The 3-day notice simply states the landlord intends to proceed with eviction. Some tenants believe that is their eviction notice, but it actually is not, correct?
It's dependent upon what the landlord wants it to be. So in North Dakota, you have to give the 3-day notice and say that says, if you, I'm terminating you, and here's your 3 days to get out. Now, sometimes what will happen is prior to the point where you get to the eviction process, if you send a notice that says, okay, I know you're past due, I know you, here, let's work with you. Those notices can be sent. Once you send that notice of intent or a notice to quit, you are at the precipice of now we're proceeding with eviction. So that is you've got 3 days to vacate the premises. Once that's the purpose of the notice to quit, is eviction is now commencing. 3 days are going to elapse. If you're not out in 3 days, then I'm going to proceed with the next step of eviction, and that's the summons and complaint.
Okay. Next one. If they move out within the 3 days, do you recommend continuing with court?
Good question. I often have that come up with some of my clients. It's up to you. If you're in a situation where the breach of the lease is regard to they're smoking in the property or they're breaking the law in the unit, then at that point, if the 3-day notice serves its purpose and they vacate, I don't recommend proceeding with the other part of the hearing. You can go ahead, you can dismiss it. But if it's a situation where we're talking about past due rents and they're in the unit and they owe maybe, several thousands of dollars, and you as the landlord want to secure a judgment for those past due rents, then I do recommend proceeding with the hearing, because that's the way that you get the financial monetary judgment that if you decide you want to try to collect on later, that's how you get that. So you have to proceed with that. Otherwise, you stop the eviction process and then you try some sort of collection action, a separate collection action later. You can certainly do that. But since you've already started the process going and you've already pled it and you've already said those things in your complaint, just finish it. And that way you get your judgment, and what you do with your judgment is up to you. Sometimes, it's very hard to collect on the judgment if the tenant doesn't have any money, or obviously if they're not paying their rent, there's obviously financial considerations there to be taken into consideration. But if you're that far into the process, just finish it.
If someone is living in a home with the understanding that they are to care for the land and home, but not doing so with no rent collected, how do you go about evicting them if they are not holding up their end of the agreement?
Well, that gets to be a little bit more of a civil litigation type of situation, because from what I'm gathering by the question is that's just not just a simple rental situation. There's a whole lot of other considerations that are coming into play, and that may involve labor, other additional considerations, which is why it's very important that you document these things, that you, before you have anyone come onto the property or do anything, you sign some sort of written agreement that outlines the parties' understanding so that you don't have these situations come up. Now, if you find yourself in a situation where it has come up and now you're wondering, well, now what do I do? It is possible potentially to proceed with an eviction. You still can proceed even if there's a verbal agreement potentially, but just understand that if you're the landlord in that situation and the tenant counterclaims or does something that says, you know what, there's more to this story than just a simple eviction, you could find yourself in a situation where you're litigating something more thoroughly in court that's a lot more extensive than just a simple eviction.
Okay, we have had times when the judge won't, we have had times when the judge won't aware the fees, even though it is in the lease. Is there any way we can push back?
That's a good question. You know, sometimes I think it's dependent upon the judge. I've had one judge tell me a few times, I'm not going to impose late fees because they're penalties. And my response has always been to the judge, well, they're contractually agreed to when the tenant signed this lease. And so I've had the same judge who told me he wasn't going to award them. So I think the position on that is if they disagreement, then you ask for them. If the judge does not award them, then you know the judge is potentially within his or her discretion to do that. I have had that happen in some circumstances, but most of the time, the judges, at least in our district, have awarded them. I don't know what it's like in the other districts outside the Southwest, but I think the contractual agreement is what it is. And if they're in there, then ask for them.
Does the 10-day notice have the same concept as the 3-day notice?
There is, unless there's something specific with regard to your own unit or what you're requiring for a 10-day notice, but under North Dakota law, the only requirement is that a 3-day notice be given prior to eviction. So if you're requiring them to give a 10-day notice, if that's something that's in your lease agreement, then obviously you have to do that. But there's no North Dakota statute that says you have to give a 10-day notice for anything. It's the 3-day notice.
If a tenant leaves the property and has left behind personal items of less than $2,800 worth of value, how long does the landlord have to wait to remove it if the tenant had been evicted?
I believe, if I recall correctly, I think it's 28 days, if I recall correctly. So you have to store them for 28 days if that property is not collected, or you know, the tenant doesn't call and say, hey, I'd like to get my property back. That's technically considered abandoned at that point. I would always recommend that if there is an eviction, there's nothing wrong with sending a follow-up letter to the tenant saying, listen, you left this stuff in the property. I'm giving you this amount of time to come get it. If you don't come get it, I'm going to dispose of it. Because if it comes down to that and a tenant comes after the landlord and says, well, you throw away all my property. Well, you can say unequivocally, I sent you a letter that says what was going to happen with this property. If you choose not to do anything with it, or you choose not to act on it, that's on you. So it's just another way for the landlord to cover their rear end and document what you're doing. So if it's ever questioned, you've got something on paper that says, I did this, and then it's back, and then the burden shifts back to the tenant.
So if you have an in-kind agreement of living on the land and caring for it, but not upholding your end, can the landlord write a lease later and ask you to sign it? And is this legal?
The short answer is yes. I'm sure you could backdate a lease agreement. You know, that is something that parties could mutually agree to do. Whether they do that, I guess that's going to be a decision between the two parties. But again, it goes back to, yes, you should have something in writing. If you do it after the fact, you know, sometimes that happens, but at least you have something in writing moving forward that outlines the parties' rights and responsibilities and obligations to one another.
Last one right now. If you communicate via USPS, do you recommend a certified letter with return signature?
I would say it depends on what you're serving. You know, if it's a situation where you're sending a notice of some sort, maybe it is the 10-day notice or something like that, certified mail is always a good way to do it. You know, maybe you don't have to go as far as getting a return receipt requested, but you certainly could. There's never going to be a situation where it's bad to go above and beyond. So if you think that that's appropriate and you want to have that documented to ensure that they got it, by all means, more power to you. That's only going to help you in the long run if anyone ever questioned it. And then you've got documentation to support your actions and that the tenant was given notice.
Are there any more questions? I think that seems to be the last of them.
Perfect. Well, I have enjoyed my time with everyone here today, and hopefully somebody found it useful. And I have shared the PowerPoint with Ms. Erickson. So if anybody would like to use that for their own personal information, by all means, that's what it's there for.
All right. Thank you so much, Chirstina.
Yep, you're welcome.
Those of you that are still on, just a quick announcement for next week's presenter. We have Dawn with the North Dakota Safety Council doing another training on, safety, personal safety, and keeping safe. So hopefully you can tune into him. He's a phenomenal speaker as well. And that his presentation will wrap up our online trainings for the year of 2020. So hope to see you all next week. And again, the survey will be coming out here shortly. So just, it always helps us when you respond with any feedback. Any and all feedback is great. So please take a couple minutes to fill that out. And like I said, hopefully see you guys next week. Have a good day.